Hi everyone, my name is Beth Brown and I am counsel in the Pensions Group at Mayer Brown. Welcome to this episode. In these episodes, we cover different topics each month, providing an overview of the issues faced by pension industry practitioners and offering some practical insight. The time spent listening to these episodes can count towards solicitors' continuing competence and PMI CPD requirements. All the episodes are available on our Mayer Brown YouTube channel, as well as iTunes, Google Play and Yahoo. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. In this episode, we will be looking at the guidance that the Pensions Regulator, or TPR, has produced. TPR has been very active throughout the COVID-19 crisis and has helpfully produced a lot of guidance. In this episode, we intend to give you a summary of all this guidance and highlight what we consider to be the key points. The guidance TPR has released has been aimed at providing schemes, trustees, and other key stakeholders with the support and advice that they need to steer through the crisis, including 1. Guidance for defined benefit scheme trustees on funding and investment. 2. Guidance for defined benefit scheme trustees whose sponsoring employers are in corporate distress. 3. Guidance for trustees on scheme management and investment. 4. Guidance for trustees on communicating with members. 5. Guidance for avoiding pension scams. 6. Guidance for administrators on late payment reporting and PASA guidance. 7. Guidance for employers on scheme funding and automatic enrolment. 8. Guidance for members by the Pensions Advisory Service on how COVID-19 will affect pensions and staying calm. 9. An update on activities during COVID-19 and protecting members' benefits. And 10. An update on trustees' reporting duties and TPR's approach to enforcement action. In addition to this, TPR has joined up with the Pensions Ombudsman, the Money and Pension Service, the Financial Conduct Authority, the Pensions Protection Fund, and the Financial Service Compensation Scheme to produce a joint guidance document entitled COVID-19 and Your Pension, which was released on the 27th of May. All in all, you can see the TPR has been very busy. Whilst the guidance is just that, and it's not legally binding, schemes and trustees are far more likely to find that TPR will take a pragmatic and sympathetic approach if the trustees and scheme have complied with the guidance. We will now summarise the key points arising from the guidance. I will start with the key points for defined benefit scheme trustees. It's worth noting that DB scheme trustees who are finalising their valuation during lockdown can delay submitting scheme documentation to TPR for up to 3 months without TPR taking regulatory action. Trustees finalising their valuations during lockdown will not need to revisit their assumptions or take into account post-valuation experience in light of the market disruption caused by COVID-19. However, TPR does recommend that the recent disruption caused by COVID-19 be taken into account when considering if the contributions are affordable by the employers in the current circumstances. TPR has also helpfully said that it will not take any action against trustees who suspend the quotation and payment of cash equivalent transfer values, or CETVs. This relaxation applies until the 27th of June, although trustees can continue to suspend CETVs for longer if they consider that it's in the best interest of their members to do so. If trustees do this, they should notify TPR in the usual way and be clear about their reasons, which may include, for example, significant financial market uncertainty, leading to uncertainty over the appropriate CETV terms to apply. Moving on to the guidance for DB scheme trustees whose employers are in corporate distress, the key here is that TPR is encouraging trustees to agree to employer requests to suspend deficit contributions, with a view to helping to keep the company afloat, as long as certain conditions are met, such as 1. The employer entering into a legally binding agreement not to pay any distributions or dividends. 2. The employer not paying any intergroup transfers unless the trustees understand the rationale and such transfers are covenant enhancing. And 3, the suspension not being longer than 3 months, unless the trustees have full visibility of the employer covenant. TPR emphasises the importance, if the sponsoring employer is in financial difficulty, of the trustees really understanding the employer's covenant and business plan to the fullest extent possible. Trustees should also take appropriate advice and ensure that other creditors, such as banks, are also being supportive prior to agreeing any request to suspend contributions. TPR has helpfully published a list of questions that trustees should ask of employers where the employers are in distress. Next, I will look at the key guidance in respect of scheme investments, communicating with members, and pension scams. As you would expect, the market volatility which has followed COVID-19 will also have an adverse impact on the investment and funding strategies of many schemes. Trustees of DB schemes should consider with their investment advisors whether there is any action required in the short term. So, for example, whether planned investment changes or de-risking exercises should go ahead, as well as how the funding journey plan is affected in the longer term and whether there are any strategy changes that are needed. Trustees of defined contribution schemes should also consider whether there is anything additional that they should communicate to members about the situation. It's important that trustees maintain a dialogue with members during this time. This is understandably a really worrying time for members. Not only will they be concerned with the human impact of COVID-19, but many will also be concerned about the impact on their personal finances, including their pension pot. The state of the financial markets, and in particular, a perceived instability of their sponsoring employer, could result in some wanting to transfer their benefits, which could in turn increase their vulnerability to scams. Trustees should counter this by ensuring that schemes stay in regular contact with their members, allaying their fears where possible, and reminding members to be wary of potential scams. Naturally, the specific nature of what is communicated will vary from scheme to scheme, but correspondence may include, for example, confirmation that benefits are still secure, even if there may be a delay in processing requests and payments, and/or maybe telling members about general steps being taken by the scheme in the current circumstances of COVID-19. It might also be helpful to refer members to the joint guidance document entitled COVID-19 and Your Pension, and the guidance by the Pensions Advisory Service on how COVID-19 will affect pensions and staying calm. I will now move on to reporting duties and TPR's approach to enforcement action during the current crisis. TPR has been very clear that it understands the current circumstances that trustees, employers, and administrators find themselves in. And while it cannot waive statutory deadlines, it will take a pragmatic and proportionate approach to enforcement. In particular, TPR has stated that if a breach of an obligation can be rectified within a short time frame and it does not have any negative impact on savers, then there is no need for the trustees to report it at the moment. However, trustees should ensure that they keep an internal record of any decisions made and/or actions taken. Also, TPR will review any enforcement action needed on a case-by-case basis, taking into account the relevant circumstances. These easements will remain in place until at least the 30th of June. However, there are quite a large number of areas where the flexibilities will not apply, such as the chair's statement. Trustees should ensure that they are aware of which areas are covered and which are not. In addition, in recognition of the strain that is placed upon many employers at the moment, TPR is asking trustees to report late contribution payments once they are 150 days late, rather than the standard 90 days. That's 150 days late. It's hoped that this extension will give trustees time to work with the employers and bring the payments up to date. This seems like a good time to move on to the guidance for employers. So, consistent with the approach taken with trustees, TPR will be mindful of the current circumstances when considering any enforcement action and is encouraging employers to work with trustees. In particular, TPR asks that employers continue to provide trustees with the necessary information. TPR has also provided guidance for employers in relation to the government's coronavirus job retention scheme. This coronavirus job retention scheme provides essential support for employers and will help them continue to make pension contributions. While we all know that pension contributions may be reduced during the current time, employers must still ensure that they continue to meet their automatic enrolment obligations, which includes paying the minimum employer contributions. As you can see, there has been an abundance of guidance for trustees, employers, and other stakeholders. But I think the key takeaway is that all stakeholders need to work together in a pragmatic way to achieve the paramount goal of protecting members' benefits during this incredibly difficult time. That concludes this episode. Please do feel free to email me with any comments or questions on this episode to bbrown@mayorbrown.com. This episode is an overview of the law and guidance in this area, and how the law and guidance will apply in any particular case will depend on the individual circumstances. Please therefore remember to seek legal advice on your particular circumstances. Thank you for listening.